Good morning, everybody. Aloha. Thank you for being here this morning. My name is Rob Hack. My company is Insight Inter-Asia, and I'm on the board of the Hawaii Pacific Export Council we call HPEC. And HPEC is a local nonprofit here in Honolulu tasked with helping companies export and learn about exporting. HPEC has a grant this year, and we've had this grant for a few years now from DBET, which allows us to put on these seminars and then do one-on-one mentoring with companies about exporting topics. DBET in turn gets their grant from SBA in Washington, D.C., and Hawaii does quite well in that every year, and we're very thankful to have that grant, and I feel like we use the money quite well in teaching our companies about exporting. Before we get started, I'd like to give one disclaimer that obviously we have cameras here. We're also on a live webinar. Any question you ask will be part of a public forum, and it's quite possible that your face may be on our YouTube video at some point. So we do have a live webinar going on. We obviously have a live audience here, and we are recording this. And I'll show you very briefly where we have our YouTube library archive of lots and lots of exporting topics here, which I think is very relevant for the audience. So please feel free to go back and look at this at Hawaii Pacific Export Council on YouTube. I also want to point out that I've been doing this show on the Think Tech network called Exporting from Hawaii, where I'm interviewing government officials involved in exporting and companies that are involved in exporting, and they're talking about lessons learned here. And I think there's been some very interesting people on that show, so please have a look at that. Very briefly, here's the Hawaii Pacific Export Council website, where you can find lots of information and upcoming details about our seminars that are going on. And I'd also like to point out that next week we're having a seminar exactly the same time, Thursday morning, 9 a.m., just on contracts for exporters. It's sort of a follow-on to this legal-oriented seminar. That one we're doing next week is an HPEC event specifically on contracts for exporters. So I think that that could be also interesting. With that, I'd like to bring Jamie Lum from DBET up to say a few words and show you also the DBET website. And there's a whole section here on exporting. If you click on this link, there's lots about the Hawaii State Trade Expansion Program, HiSTEP, which is funding this particular seminar today. So we'd like to say thank you to Jamie and DBET for that, and please.
Thank you, Rob. Aloha and good morning, everyone. Thank you all for being here. As Rob mentioned, you are participating in a session that is part of what we call our HiSTEP program, which is the Hawaii State Trade Expansion Program. It is funded primarily through a grant from the Small Business Administration. It is a grant that's available to all states and territories, and the goal of it being to increase the amount of U.S. exports, as well as increasing the number of companies that are exporting. So those are the main goals of the HiSTEP program. Rob has it on our website. Just remember, Invest.Hawaii.Gov is our website, and if you go under exporting, you can find all the information that I'm just going to briefly go over under the HiSTEP. So we have three components to the program. The first being what we call our export readiness program, of which these series of seminars, which we've been working with HPEC for a number of years now on this, putting these seminars together. We have other partners. We work with the Small Business Development Center. We work with Innovate Hawaii under the Hawaii Technology Development Corporation. We work with FTZ. We work with the Ming Center. So all of these organizations help us in the export readiness in that we have these training seminars, and then, as Rob mentioned, there's one-on-one business advising and mentoring. Just to briefly go over how the process. We have online a registration form. It's really more of an enrollment form for you to get into the program. It's not something that you need to be accepted, but basically we want information about your organization, and we're interested in seeing where you're at as far as exporting. Are you a company that's just looking at exporting for the first time, or maybe you've been exporting already, so giving us some background. And then what happens is you're contacted by someone from the Small Business Development Center to do sort of an initial consultation. They'll go over the application with you and kind of get a better feel for where you're at, what your issues or needs might be, and then you will be either they'll continue to work with you, or you may get referred to, depending on what your issues are, to our other partners like Rob at HPEC or like Innovate Hawaii if you have manufacturing issues. So that's all part of what we call our export readiness. Once you, and hopefully through that, and not everyone has to go through that to participate in other elements of the program, but that will hopefully give companies a good resource for venturing out into trade shows, which is another area. We have our Hawaii pavilions, and we select particular trade shows to go into, and we organize. What we do is we buy space, and then we put out a call, a recruitment for companies to participate with us. We have coming up next, in June, we'll be going to the Outdoor Retailer Summer Market in Denver, and then in September, there's the Tokyo International Gift Show. So you may, if you're already on our mailing list, you may have already seen some of those recruitment notices, and I believe the Tokyo Gift Show one will be going out shortly. So what we do is we pay for the majority of the cost to be in the trade show. Then we assess a small participation fee, which is, I would say, at least a third at the most of what you would spend if you were going into the show on your own. So we try to make it affordable for companies to participate, as well as going to these shows as a group, so we can all go in under the Hawaii brand. And as you all know, that's a very powerful thing when you're showing in these big shows. So that's another component, is our trade shows, our Hawaii pavilions. The last component is our company assistance. First, I have to say that part is actually already completed for 2019. We've already selected the companies that have been awarded. But basically, it's an opportunity for you to put together an export development plan if you don't already have one. And hopefully, the sessions that we have and the business mentoring and advising that you receive will help you in putting an export plan together. But you would apply to us to be able to get some funding to help support some of your export efforts, perhaps outside of things that DBED might already be doing. Other trade shows you might want to do, maybe a gold key in a country that you might be interested in exploring and working with U.S. Commercial Service and things of that sort. So those are the three components. Again, if you go on our website, all the information is there. To qualify for HiSTEP, you have to meet basically be a small business under the definition of SBA, and I think pretty much most companies in Hawaii would qualify. There are some other elements. One of the things that did come out this year is that your product does have to be U.S. made, either originated in the U.S. or meet that 51% value of to your product has to be U.S. So. And then, you have to be registered to do business in Hawaii and so forth. So all of the criteria are on our website, and that's just a brief overview. If you have any questions, feel free to contact myself. My colleague Marlene Hirooka is also here, and she can answer questions. And thank you very much.
Thank you, Jamie. Okay, the topic of today's seminar is protecting your brand when exporting. This is an important topic. We've done this now 2 years in a row. Last year was a little bit different because we also included some information about patents. But we found over the years that patenting, although these guys might disagree somewhat, patenting is not a huge effort for our Hawaii companies. There are some companies here who should be patenting their products and services, but more so, I think, the companies that we meet with at the Hawaii Pacific Export Council need to get their act together with regard to trademarking. And that's a very big issue internationally. We've had some companies here who have been in the news for losing their trademarks or not having had a trademark or a logo or what have you filed in a foreign country that they were working in, and they lost the rights to that in that country. And that can be very painful, particularly for a small company. So we're going to talk a little bit about that today. We have two of the most senior and experienced intellectual property attorneys in Hawaii with us today, Martin Shah from Cade Schutte and Seth Reese from Watanabe Ing. And I thank them, and the Hawaii Pacific Export Council thanks them very much for sharing their time with us today to review with you topics about trademarking and intellectual property protection in general, particularly for exporters. That's what we're really worried about today. I would also like to add that I received some materials from the DCCA here in town, the state government people, about what they can do for companies who are looking to trademark. And if there's time at the end, I can go through a few of those slides. So what I would suggest is let's let Martin and Seth go through their talks, and then we'll have an extensive Q&A session at the end. And the online audience, feel free to type in your questions along the way, and I'll ask the questions verbally at the end. If you do ask a question, I ask please speak loudly so that the online audience can hear what your question is. Okay, so with that, this morning we're going to start with Martin Shah. As I said, he's from Cade Schutte, and he has a brief presentation. And do you want to show that website first, or what would you like to do?
Let's show the website first. Morning, everybody. I'm going to start off with a warning. One risk that you're going to run into that is not immediately apparent is that you are going to be solicited by all these fraudulent companies. What's on the the display right now is the website for the United States Patent and Trademark Office. There is a particular page relating to non-US PTO solicitations. Basically, there's something in the middle of it right now, but anytime you do anything in terms of filing trademark applications at the U.S. Patent and Trademark Office, everything becomes a public record. You will be inundated with fraudulent notices saying file here for international registration, and there are going to be invoices, and ignore them all. And the other point I should make is that you should not try to do this yourself. I've seen many people use, and I will say it, LegalZoom and other companies to try to register trademarks, and they're wrong. And I have been able to fix some messes, but other messes I cannot. You're fooling around with stuff that's really important. In the US, it's nationwide rights. In foreign countries, it's nationwide rights in that foreign country. A fundamental concept that you must be aware of is that trademarks are country by country. Each country is different. The other thing you should be aware of is that just because you think you know what it is in the US doesn't mean it's the same in foreign countries. Foreign countries follow mostly the same kinds of general principles. So that's why I'm going to, Seth and I split this up, so I'll handle the substantive stuff, the substantive law principles, and then Seth will handle the procedural stuff. About how long should I speak on this?
30 minutes if you can.
Okay.
It's up to you.
I could talk 2 hours if you want.
No, that's all right.
So I'll set my stopwatch for 30 minutes. I have 2 words to introduce this segment. Kona coffee. So some of you may be aware of the fact that Kona coffee is a very well recognized type of coffee and has a worldwide reputation. When we say protect the brand, your brand, there are 2 brands that are really at issue here. One is the brand of Hawaii. And I have to say that unfortunately, most people in Hawaii, and that includes all stakeholders, have fallen down on this. If you may be aware of the fact that Kona coffee acquired such a great reputation that people started fraudulently blending things, or even just saying there's Kona coffee and had nothing whatsoever to do with Kona, which is really bad for all of the people that are farmers in Kona. Plus, each of those farmers had their own particular brands for their own kinds of coffee. And if they had taken the correct steps earlier, then they would have been in much better shape. Seth will go into this more, I think, but there are geographic appellations of origin, which means that you have a particular area that's known for a particular product. And some of you may remember there used to be something on the market called California Champagne. Well, Champagne is actually a wine-producing region in France, and part of the World Trade Organization amendments were requiring that you could not use those kinds of appellations unless you were from that region. And so we're seeing this kind of activity, which the United States is joining in terms of making people not allowing them to use appellations of origin that may be deceptive to the marketplace. So we're seeing it with wines. You may be seeing it with cheeses and various other kinds of products as well. Domestically, we have that, Idaho for potatoes, for example. So when a geographic area becomes known for a product, then what often happens is that either a government entity, such as the state of Hawaii Department of Agriculture, which did indeed ultimately register 100% Kona coffee as a brand at the U.S. Patent and Trademark Office, or you have a nonprofit organization that's a trade association for that particular region, such as the Idaho Potato Growers Association. They will go and register a seal indicating that the product is from that region. The Hawaii brand is very, very popular in the world, and people in Hawaii are just not aware of that, and that's allowed a lot of people to register the name Hawaii, and they have nothing whatsoever to do with Hawaii. And so I have, for example, a situation where my client had a trademark registration in the United States for when mark containing the word Waikiki, and has run into problems in Europe. I've had others, a specific case where my client's product trademark was the name of a resort it developed, and somebody else had registered the name of that resort, again, in Europe. Hotbeds of trademark piracy include Brazil, Europe, Japan, Australia. So just be aware that people do steal things, and also cyberspace is just another country. So people will steal your brand in cyberspace. So what I'm trying to give you now is information about what risks you should be aware of. I think the newspapers reported quite well on the issue of Aloha Poke, where Aloha Poke had nothing whatsoever to do with Hawaii. It's a Chicago-based company. But at least there you have U.S. laws applicable. Other things you should be aware of in foreign countries, in most of them, they don't speak English. And so you have to be conscious of that. And by the way, I am not going to be discussing any of the other issues you may run into in exporting. For example, there are certain ingredients that are acceptable in U.S. Cosmetic products, and they're not going to be acceptable in foreign countries. So it's a very nasty surprise when you say, I'm going to export my stuff to this country, and you find out, oh, the ingredients are not acceptable there. And similarly, packaging, there may be language requirements. You want to sell in Canada. Canada, that's not a third world country. French language requirements. So you need to be aware of these kinds of things. And importers into the United States similarly have to be aware because their labeling is probably in their own language, and they probably don't meet FDA requirements. So anyway, just a caution, I'm not addressing those kinds of issues, nor am I addressing patents or copyrights. And for those who are interested, I have some patents and copyrights here so you can see what the certificates look like. I did bring along a federal trademark registration certificate in the United States just so you can see what it looks like. This is an old one. It's expired already. The real ones I give to my clients because I don't want to have them. But they have, they basically have a nice, they look quite nice. And it's something that's really, really important to have. So anyway, in terms of protecting your brand, starting from the very fundamental principle of, one, protecting the fact that you're from Hawaii is something that is not up to you necessarily unless you're part of a nonprofit organization for the trade industry. I have given a speech to a trade industry group, and I told them about Kona Coffee, and I told them what they should do and what Kona Coffee should have done. And I have not been contacted by them in terms of trying to help protect the branding for their particular kind of product. And it is an agricultural product. But that's because of the whole nature of nonprofit industry groups. They don't have the money and don't want to spend the money on protecting something that would be the good of all, because it's really difficult to even make payroll every month. So I'm very aware of the fact that you have to allocate your resources efficiently and effectively. And when you're trying to make payroll every month and keep the lights on, thinking about things that are 5 years down the line is just not something you're going to pay attention to right now. But these things are things you have to think about now, ahead of time. Because I'll tell you, the most important part of protecting your brand in exporting is selecting the brand. If you choose a brand that creates all kinds of problems, you're going to spend a lot of money on me or Seth or somebody else in trying to deal with rejections from foreign patent offices and foreign trademark offices as well. Some countries have their trademark office in the patent office, including the United States. Other countries, it's a separate office. So selection of the brand is probably the most important thing. And the business people, the first thing they want to say is usually, oh, I want to protect, oh, what's a brand? What's a trademark? A trademark is a designation of some type. Typically, it's a word, or it's a design element, a logo, for example, that you adopt to identify your goods or services and distinguish them from the goods and services of your competitors. Everything in an economy is goods or services. You can either touch it or it's something someone does for you. And that includes land, because land is something that the government provides the services of saying, we'll send police to kick someone off if they trespass from you. Except that you're not paying for the government. They force you to pay them through taxes. But if you think about it, and this is my analysis, everything that you don't do yourself is goods or services. And you trade for it with money. Money is just a medium of exchange. When you had Allied prisoners of war in World War II, they had a medium of exchange, cigarettes. Various other cultures have other media of exchange, such as shells, dollar shells, for example. So money is just a medium of exchange, and what you're doing is you're trying to buy brands, buy goods and services. And what you want, the reason you have a brand is because you want to have a reputation for your brand that encourages people to pay more money for your brand, or at least prefer your brand, over your competitor's brand. If every hamburger store said, or hamburger restaurant said, hamburger restaurant, and that's the generic term, and there was no indication of differentiating one from the other, then you wouldn't be able to say, well, I prefer this one. So trademarks are actually the most valuable species of intellectual property because they allow you to reach into the mind of the potential customer and make purchasing decisions. I don't understand why, but women pay $1,200 and more for designer handbags. To me, I'm a guy. I think that it's just a bag, but I'm functional. But there are examples for men as well. I think that people should realize that branding is a very, very important exercise. The difference between the highest level of Toyota Camry and the lowest level of Lexus is about $7,000 and a nameplate. They're basically the same. Clorox is chemically identical to every other chlorine bleach. And I don't understand people saying my water is better than somebody else's water. It's dihydrogen oxide. It should be chemically pure. But those are my thoughts. But with the right branding, if you get brand recognition, it is so valuable. The S&P 500, probably about a third or somewhere around there, of the value of the companies is an intangible asset called goodwill. Trademarks are the badge of goodwill. And goodwill is basically the likelihood of future business. And what you are doing with a trademark is you're creating a reputation, and people are going to buy based on that reputation. So with that background on what brands are and why they're important, because if you do indeed have a good brand, people will prefer you and you will be able to make more money. If you have a brand that went down in value, all of a sudden you lose value. And I think you can see from the most recent very, very unfortunate incidents with the airliners that crashed, I think the value of the Boeing brand has taken a huge hit. And so that's something that you should be aware of. And Airbus, there are major competitors taking advantage of that in the marketplace. So you just need to be sure that your brand is protected, because you also don't want someone else stealing your brand or having a confusingly similar brand in a foreign country. So can we go to that one slide I have in my slideshow? Remember I said protecting your brand in a foreign country, the very first thing is selecting it. So what we have is trademarks are in a spectrum of distinctiveness. The spectrum of distinctiveness of trademarks is this. Some designations are protectable and some are not, and some are protectable only under certain conditions. So the first thing is generic terms. Generic terms are not protectable. What's a generic term? Car for cars is a generic term. It's the name of the actual product itself. You cannot have an exclusive right. That's the whole point about brand names. You want to have an exclusive right, the right to exclude others from using something that is confusingly similar. So car for cars is a generic term. Apple for apples is a generic term. Those are generic terms, and they cannot be protected under any circumstances. And that is something that is a fundamental point that you must be aware of, because if you pick a brand name that is, for example, a generic term in a foreign country, you're going to be rejected. Almost all foreign countries have the same kinds of procedures that we have in the United States. You file an application. Some countries have examination. Other countries just allow it to register. There is often a period of time, limited, 3 months, 30 days in the United States, 3 months in the European Union, where you can say, I object, and file what's called an opposition. And then after the registration issues, then you can have what's called a cancellation, where someone says, I want to cancel this registration. And there are various grounds for opposition and cancellation, which I'll touch on a little substantively, but Seth will probably touch on more in more detail. So the next, so I gave car for cars. On the other end of the spectrum are designations, brands, words, or logos that are strong. They are immediately protectable upon adoption. Once you adopt these and use them, then you have immediate protectable rights. Arbitrary terms means a word in the English language that has nothing whatsoever to do with the product itself. Apple has nothing whatsoever to do with computers. So Apple for computers is an arbitrary term. Kodak is a made-up word. It doesn't have any meaning in the English language except for a trademark. Same thing for Exxon. That's called a coined term. These are the strongest kinds of trademarks, and they are protectable immediately upon adoption and use. The problem is that you don't know whether somebody else may have similar, confusingly similar names. But you should be aware that when you're choosing a brand name, your trademark attorney will say, okay, you should pick the one that's the strongest, because that's the easiest one to register, the easiest one to protect. Next slide, please. Xerox, I gave you an example. ABC. Now, there are some places which will say ABC is actually not an arbitrary term because it's just the first 3 letters of the alphabet. In the United States, that hasn't been the case. Xerox is indeed a very arbitrary term. Okay, next set. Yeah, the next, and this is where most businesses without good trademarks counsel fall. They pick a descriptive term. It's either a term that directly describes some attribute or characteristic of the product or geographic attribute of the product, and therefore is not protectable. It's not protectable because other people in the same geographic area or other people who are competitors have the right to describe their products as well. You cannot take words out of the English language, if we're talking about English. You cannot take words out of the language and stop your competitors from using them, because they have the right to use those terms to fairly describe their products. So digital for computers is one example. Computers work on zeros and ones. That means they're digital computers. They're not, some computers are analog, but most computers are digital computers. So using the term digital computers is a descriptive term. And that's why it's a weak term. However, if somebody has a weak term, and surnames are in the same category, somebody who has a common surname, something that we recognize as a surname, would not be allowed to protect it because somebody else with that same surname would be able to have the right to use that same surname in their own business. McDonald's is a very common surname. Okay, next slide, or next. Honolulu, for a magazine about items in Honolulu and what's going on in Honolulu. That's not protectable immediately upon adoption and use. However, if this descriptive designation or laudatory designation like best for foods, if these designations have acquired recognition in the marketplace, then that recognition can be protected. That's called a secondary meaning or acquired recognition. The reason it's called secondary meaning is because the term has two meanings now. One is the primary descriptive meaning of, oh, a magazine about Honolulu. The second is a second meaning, which is, oh, a specific magazine that I recognize as having seen before that runs the Best in Honolulu, for example. I am familiar with this magazine. It's recognizing as a source. So now the term Honolulu for magazine has become a source indicator. It has a second meaning identifying a brand. McDonald's has a second meaning identifying a brand of McDonald's. Golden Arches, French fries, and all that other stuff. And these principles are very, very common throughout the world. And just so you're aware of it, that it happens in the U.S. Patent and Trademark Office, California Pizza Kitchen was properly refused registration for being a geographically descriptive and a descriptive term. They appealed that refusal to the Trademark Trial Appeal Board and lost, and it was a correct decision. It was, they made all kinds of arguments saying, well, it's a style of pizza or whatever, but it was a geographic term, and Pizza Kitchen is generic for a place you go to get pizza. They had to then file a new application saying, okay, we have acquired enough recognition now. And then that's why they were recognized, and then they got onto the register. Same thing for Windows, for computer software by Microsoft. So these issues that I'm talking about, they also catch big companies. Your goal as an exporter is to make sure that you become a bigger company because we need to diversify Hawaii's economy. The only thing we really export in quantity is land. So what we really want to do is diversify our economy. I mean, I live here, one of my kids lives here. We want to make sure this economy stays strong because the fundamental reality is we're a little speck in the middle of the ocean. Next slide, or next one. Yeah, foremost, that's a laudatory term. But it has become recognized as a brand name, in Hawaii anyway, as a brand of milk, and that's why it's protectable. Now, the point that you need to be aware of is that when you have the secondary meaning is protected, which means that the brand designation, the brand meaning is protected. But you have not and cannot take the word out of the English language, which means other people can continue to use that term in its primary original descriptive meaning. My milk is the foremost kind of milk, or my computer operates in Windows on your desktop. That is not a trademark infringement because it's usage of the term in its primary original English meaning. Trademark infringement means that somebody else cannot adopt and use a term that creates a likelihood of confusion, is likely to confuse people into whether you're affiliated with the other company. Either your products, I mean, there could be counterfeiting. So I've done the seizures over at Aloha Stadium where you go and get the counterfeit bags and the counterfeit watches, go with the sheriffs and all that other stuff. And that's kind of a lot of fun. We haven't done that for many years, but it's a lot of fun to go in there and grab the stuff. Those are counterfeit bags or counterfeit watches. And there's a whole trade in counterfeits that goes on there. And hopefully we keep that down to a dull roar in the United States. But then there's also just garden variety trademark infringement, where the names are not necessarily identical. Someone's not trying to deceive you, but they just happen to be relatively close. Either the names are close, but the products are identical, or the products are slightly different and the names are identical. But there are always at least two dimensions. There's always the name and the product. Trademarks do not exist in the abstract. They are always associated with particular goods and services. So that's why when you want to do a trademark registration, you need to know what particular goods and services they are. In the United States, you have protection of unregistered usage as well. And that's why it's so difficult to make sure you have clear trademark rights throughout the whole country, because someone else may have unregistered trademark rights just adopted through their actual usage. Many countries, specifically including the former English Empire countries, because they have what's called common law, will have the same kind of situation where you have acquired usage and acquired rights through actual usage without a registration. However, in other countries, specifically civil law countries like France and various others, trademark rights are acquired only through registration. And some countries, you can only get trademark rights through registration, like Korea. So you just have to know that each country is different, but most countries follow the same kinds of principles. Okay, next one. Oh, pink insulation. Colors can be protectable. So the pink of Owens Corning fiberglass was protected, and that was upheld by the U.S. Supreme Court, because you see pink fiberglass, it's a source identifier. You know it's Owens Corning fiberglass. Next slide. Yeah, McDonald's restaurants we did. Next one. Yeah, Coca-Cola bottle. You do not need to see the words Coca-Cola on the bottle. That's called secondary meaning through the trade dress. Trade dress is the packaging. And so trade dress is recognized in the United States, but other countries in the world may or may not recognize trade dress, and it can be pretty difficult sometimes in some countries. So for example, I have obtained trademark registrations for a particular client where the trade dress is very, very, very important to their business. The business is well known enough that people have copied the trade dress, and we've taken action against those people who have copied the trade dress. Easy enough to do in Hawaii or the United States. We have federal trademark registration. The problem is in foreign countries, when you try to file the federal, get the registrations in foreign countries, many foreign countries, in fact most foreign countries, really give you a very hard time on trade dress, and they should, because trade dress is protectable only if it has acquired the recognition that people see the shape or the packaging and say, I recognize that. And if you are a Hawaii exporter, by definition, if you are just starting out, you do not have secondary meaning in the foreign countries. Remember, trademark rights are country by country. So if you have adopted a particular trade dress, packaging, shape, or whatever it is, that you want to protect in foreign countries, you're going to have automatically a very difficult time, because most foreign countries will say, well, what's your recognition in our country? And the same thing for any of these descriptive terms, because if you pick a descriptive term, and McDonald's, for example, and you have not acquired the recognition in the foreign countries, the secondary meaning in the foreign countries, you won't have the right to get the registration in the foreign countries. McDonald's has had issues because they have also tried to expand to the whole MC prefix family of marks, and they lost on McCurry in Malaysia. So it's something where if you want to protect your brand, you have to think ahead, and you should make sure that you do not get ripped off by these other companies. Say, we'll register for you. You should be working with a trademark attorney and ignore anything that comes to you unless it comes from your trademark attorney. That'll help filter out a lot of the stuff. Except if you get something from, I know the Japan Patent Office has done that. Sometimes they send stuff to my client directly, and they send it to me and say, wait, that should have come to me. But sometimes that comes to me directly. But be aware that there's a whole school of sharks out there waiting to try to prey upon people who file trademark applications. So that may be the most valuable information that you get today. Ignore all those fraudulent solicitations. Okay, next one. So my best advice to clients when they're trying to select a brand is pick an indirectly descriptive mark, something that does not directly describe an attribute of the product. So examples I give are Igloo for coolers. Igloo does not directly describe a cooler. However, igloos are in cold places, and that's why you make a mental effort to link the name and the product. And if you do that, then you have a suggested mark, and that can be protected immediately upon adoption and use. You can file your federal trademark application or your foreign one, and you won't have a problem, or should not have a problem, with descriptiveness. The other example I give, next slide, oasis for water fountains. Oasis does not directly describe a water fountain, but if you're thirsty, you want an oasis. And so I once spoke to the in-house counsel for Oasis water fountains, and I just told him that I use your brand name in speeches all the time when I'm talking about trademarks. He found that kind of interesting. But yeah, what you want to do, picking a brand name is almost as difficult as picking the name of your baby, because this is going to symbolize your reputation, not just in the United States, but also in foreign countries. And you want to make sure that you are selecting the right brand for the image that you want. There's another factor you need to really think carefully about. How will it translate? There are a lot of cultural issues that you have to think about. For example, if you pick a brand name that may work in one dialect of Chinese, it may not work in others. And there may be different issues with respect to the translation. There are two kinds of translations you do. One is a conceptual translation, where you're translating it into words in the foreign language that mean the same thing. The other one is a phonetic translation, katakana is an example, where you translate it into something that sounds like the same thing. So you need to know whether you're going to do a phonetic translation or a conceptual translation, and then you got to check, if you are definitely going to go into a country, you need to check whether the brand is available with that translation, because you may or may not be selling it with the translated brand in the foreign country. A word here about what you should actually register. People communicate orally. I'm communicating orally right now. So trademarks are usually words, and then people think about logos as well. Logos, that is, words with, well, design elements with or without words. That's what I'll call a logo. A design element, a visual designation with or without words. Logos can change. You may keep the same words, but decide you change your logo. Many people refresh their brands. How? They change their logos. Well, if you get a federal trademark registration for a logo, or a foreign registration for a logo, and then you decide, oh, I'm going to change the brand image, I'm going to change the logo. You just wasted all that money you spent on the federal and foreign registrations. So my advice to all clients is always, always, always register the words alone without any design, without restriction to any designs. In the United States, that's called standard characters nowadays. It used to be called type drawing. And it protects the brand regardless of typeface, regardless of capitalization. And then the other thing you should be aware of is you need to work very closely with a trademark attorney who knows what they're doing. Every attorney in town will say, yeah, I can do that. But most of them have not done and are not aware of all the kinds of issues. Most of my clients are spoiled. They think, oh, you just file the application, you get it through. That's not the case with most people who file trademark applications, and I'm sure Seth can confirm this. If you don't know what you're doing, the examiner will kick you out. These are issues that you need to be aware of, so that's why you need to talk to somebody who has a lot of experience in trademark work. So I'm counsel of record in over 1,000 federal trademark applications and registrations, for example. Foreign registrations, you get them two primary ways: country by country. I go contact my correspondent in various foreign countries, say, here's the US application, or you do it through Madrid Protocol. And that's where you have a US registration, and then you go ahead and say, based on this US registration, I'm filing Madrid Protocol, and then Madrid Protocol, you get an international registration. You have to designate particular countries. And then when you designate those countries, your application, Madrid Protocol, international registration, will have an extension of protection into the foreign countries. But my half hour is up, so I'm going to turn it over to Seth now.
Thank you.
When my When my Asian friends say I'm looking prosperous, that means I'm fat. And when somebody introduces me as experienced, that means I'm old. So Martin did a very good job presenting trademark substantive. And there's a lot of material to cover, so there may be pockets we didn't, but hopefully you can ask questions about it. Okay, so the first couple of slides, I think I'm overlapping with Martin, but I think that's fine because they're important concepts and reinforcement won't hurt. You can acquire trademark rights basically two ways, but only in some places. Only Commonwealth countries seem to recognize acquiring rights through use. Those countries include the United States, Canada, England, and some other primarily Asian countries that get their law from England. So India, probably Australia and New Zealand. I haven't specifically had cases there, but I suspect so. Everybody else is registration. And so that's where you hear if you don't register first in the country, even though it's your mark and somebody else is using it because they knew it's your mark, even your distributor, even somebody who imports for you, they can run out and register your mark and take it away from you and then cut you off. We had one client do that, and they had to negotiate it back for many, many tens of thousands of dollars. So that's why it's really important to register first. Usually even before you have a presence in the country, because you don't want somebody recognizing that you have some valuable mark and beating you to it. The only exception is famous or well-known marks, and there's something called the Paris Convention. There's two big conventions in the area of trademarks. One is the Paris Convention, and it goes back to the middle 1800s, although the US adopted it much later, I think, and the other is the Madrid Protocol, and we'll talk a lot about that because it helps Americans register all over the world. But the Paris Convention says if you have a famous or well-known mark, you can boot somebody out who tries to register it, even if they got there first to register. And so that helps, but you have to have something fairly well-known. And I think McDonald's just lost a case in Europe, I heard, because they weren't deemed sufficiently famous. And I didn't read the case, so I really can't. Huh?
I think it was Big Mac.
Was it? Oh, it was the Big Mac. But yeah, it's hard to believe that McDonald's can't win a famous case, but it's a very subjective standard, and it's country by country. So you basically shouldn't bet even if you think you're pretty famous or well known. You shouldn't bet you're going to win it because it's always somewhat unclear. But I know that McDonald's usually the cases cited is there's a case in Africa, one of the countries of Africa. McDonald's was able to establish it was famous or well known there, even though it didn't yet have a location there. The other thing the Paris Convention does is that it allows you to get a trademark back from your distributor or your agent, but that's only for a limited period of time. So if your agent does register in a foreign country and they knew you own the mark, you can use a provision in the Paris Convention that's implemented through legislation in most countries who are a member of the Paris Convention to displace that person and get your mark back. Next slide. Okay, so I just want to talk about Canada really briefly because Canada's been threatening to update their trademark law for about 3 years, and they finally doing it this year. We waited a long time because those of us who like to file in with the Madrid could not use it for Canada, and clients saying, well, why? So many other countries in the world allow it. But finally, in June 17th, Canada is going to permit it. So they're changing their trademark law to conform to laws of most other countries of the world. They're kind of slow to do it. Usually it's the United States that is slow to conform their laws to the other laws in the area of intellectual property. In the area of intellectual property, countries have a tendency to harmonize their laws, and that's so that the people of their residents can get reciprocal rights in other countries. That's something that the Paris Convention facilitates as well. So, I don't know how many of you guys are interested in Canada, but in Canada, after June 17th, there'll be 3 big changes. There'll be no longer will there be a use requirement in Canada. And this is interesting because the United States is one of the very few countries in the world that require you to prove you're using your mark in that country to get rights. That's why so many people can steal your mark in other countries by registering, because they don't even have to show they're using it. There are provisions in the Paris Convention that, and in most legislations, that allow you to cancel a mark that hasn't been used. So the scheme in the United States is this. You register in the United States, and in 5 years out, you have to prove you're still using it, but you can only register it if you've used it, and then in 10 years out, you have to prove it again every 10 years after that. In most other countries, you file it, and they don't even care if you're using it. But if you haven't used it, usually within 3 years, somebody else can come and cancel it. So it's a different scheme, it's a different burden. And what's important to understand is most countries have the other structure. Most countries allow you to register without use. So Canada's going to come into that, and that's going to make filing into Canada much easier. They have something called wares. You know, we call things goods and services, and they call things wares and something else. And every country just about in the world uses a classification system for goods and services, so you register your mark in conjunction with this classification system. Canada, again, had to be different. They had goods and wares, probably from the old England, and they didn't use classifications. So finally, they're now requiring classifications. And the classifications is harmonized through something called the Nice Convention, and that's online. And anybody who wants to know where your goods and services fall, you can either use the USPTO website or the Nice Convention. The U.S. classification comes from the Nice Convention, as does the classification systems of most countries in the world. So that's the class base. So it's not. You're not going to only describe goods and services. You have to specify classes, and wonderfully, the Madrid will come into effect. And the importance of that you'll see in the next slides. Next slide. Okay, so Martin talked about this. You register, when you do registrations, you get a registration for a geographic region. Okay, it can be within a country, state. Each state in the United States has its own registration, and so do some countries have provincial registrations. And I like to talk about Italy, because Italy, at least they used to have a registration system where if you wanted a national registration, you had to register in each of the regions, you know, Umbria and Lazio. And why that is, I think, is because, you know, Italy wasn't a country until the mid-1800s, and they got unified. So prior to the 1800s, it's different regions, and then they unified. So their trademark law developed from that. But most countries, you'll just have a national registration. Most countries don't have the fragmented. And in the United States, although we have a state registration system, we also have a national. And if you have the national, then you're typically protected everywhere, and you don't. There's some benefits from also doing state registrations, but typically you might not need to. There are a few selected regional trademarks, and this is very handy to know, especially EU. EU has 26 countries. England is in a state of flux, and they're still deciding whether they're going to maintain their EU registrations as national registrations, because we've been filing in the EU to cover 26 countries or 27 countries plus, including England, and now England's leaving, so we have to figure out what's happening, and there's different ways of handling that. One important thing is Norway is not in there. And so if you think you're covering all of Europe, you have to file Norway separately. Norway is really difficult. Martin talked about descriptiveness as being a basis for refusing a trademark, and each country varies on how they view descriptiveness. I don't know why, but Norway is the most strict, and I've had the most refusals, and on appeals, they keep refusing it. Now, the other area that descriptiveness is difficult tends to be Asia for some reason. I think that's because that English is not their native language, and so when they see an English word and they look up the definition, they're grabbing onto descriptiveness. But in any case, if you want the whole EU, remember Norway is not part of the EU registration. There's a couple of other lesser known regional trademarks. One is Benelux. That was important before the EU trademark, and I think now that the EU trademark is available, that's no longer important. And Africa has a limited regional mark. I've never used it, but it's rare to file into Africa, and when we do, it's usually South Africa. Next slide. Okay, so, it's interesting. I turned off my phone, so I don't know what the time is.
Oh, you're okay.
Yeah, I know, but I want to time it so we get through it. All right, so treaties. Treaties do two things. They provide for reciprocal protection. So if you file in the United States, you can file in another country based on your registration in the United States, and sometimes get a filing date based on your registration in the United States. That comes from the Paris Convention. It's been around a long time. More recently, we have the Madrid Protocol. And that's wonderful because you can file in many countries in the world through a centralized bureau in Geneva called WIPO, or WIPO, World Intellectual Property Organization. It's a UN agency, and so that makes things cheap and easy, but it's not always as easy as you first think. So the idea is you take your U.S. application or registration, you file it into Geneva, and I think we have a slide on that. So let's go to the next slide. But the bottom line here is you have to file into every country you want protection in, whether you do it centrally through the Madrid Protocol or you do it individually through each country.
I'm going to violate my own rule and ask a question now
Sure.
that I think a lot of people would naturally be thinking. If you were going to file for a trademark, why wouldn't you just instantly file through WIPO for every country in the world?
Okay, well,
Is it cost prohibitive? Or?
no, it's very reasonable. Not every country in the world is a member of the Madrid, although it's getting better and better. And the reason why it was slow, guess anybody have an idea of why it was slow? Countries slow to adopt it. It's not by, usually countries don't join treaties because they're worried about giving up sovereignty. In this case, it was the trademark lawyers' lobby. They didn't want to lose their business, so they told their countries, don't adopt this treaty because we don't want to lose business. But they're losing out, and so it was a bunch of Asian countries, particularly they were the most effective lobbies. They've slowly been joining, and not every Asian countries, but most now. The other thing is that, as we'll discuss, it's not a magic bullet. We still get a lot of refusals, and when you file through the Madrid, you can't vary your mark. You can't say, I want this mark for the United States and Europe, but when I go into Asia, I want to change it a little, either because there's a conflict in Asia, or because it would mean something bad in Asia, or because you can't do that. You have to stick with the same mark. And so a lot of times, and I guess the other thing is, it's very economical, but you still don't want to waste money by filing it in things that you have no interest in, because it does cost something. Okay, so next slide. So this is what we're talking about, individual domestic filing. That's one option. Through foreign correspondence, you have to hire somebody in the country you want to file into, and you can do that directly, but it's usually better to do it through a U.S. trademark attorney for several reasons. One, we have relationships. One, we usually get better pricing, and one, because sometimes they don't want to work directly with a company because they're worried about getting burned, or, well, and a fourth reason, we understand the language of trademarks, the type of objections, and so the dialogue facilitates. But you do get a bill from us, so you do pay twice, but it should be cost effective. You should get a better result. And can you show that photo? I know you have to. I know this can be fun though. So there's an organization, professional organization called INTA, International Trademark Association. Is that it? INTA. All right. And they have a annual convention once a year. And just so you know, like, we have relationships with foreign trademark specialists, and one way to do it is to join this organization and go to their annual seminars. And this is us in Barcelona. It's the first time I went. There's Walter Coronel. He's another IP attorney in town, and the prior speaker, Martin, is there. We had to get Martin to pose. He was shy. But it's amazing. There was more than 10,000 attorneys, and you make appointments, and you have to go to stand under a sign and try to find the person that you're supposed to talk to. And it's like speed dating. It's overwhelming. And then they have parties that start around 5 and go to 3 in the morning because all these large trademark firms are throwing parties. We're right outside, the final party? Yeah. And that went on. There was I don't know if you've been to Barcelona, but there's 10 restaurant bars on the strip here, and they were all bought out by the organization. And so we had tickets to get in. So it's rough. It's a rough meeting because the parties are very attractive, and you try to meet a lot of people. And the problem is it's really hard to develop a personal relationship when there's so much going on. But it's also an opportunity for me to meet people I've been working with for years. So, we have several relationships in China, only one in Norway, things like that. But, I've been working with somebody for years, never met them, and this gave us the opportunity. So, going back, so that's the individual filings and the Madrid. The Madrid, you file based on the U.S. application and registration. You file it right through the USPTO. You can file first in WIPO, but nobody does that because it's more. I think that's correct. I think the treaty allows for it, but
I've never done it.
yeah, it's one of those things where it doesn't make sense because it's cheaper and easier to file through the USPTO. But the part that's not so great is that if you get a refusal from a foreign country, then you have to hire the foreign correspondent just as if you're filing directly. Next slide. Okay. If you file individually, you basically just gather the information you need and you hire your foreign correspondent and they file for you, they do all the work for you. If you're doing a priority claim, which is a claim for getting the same date you had in the US, and you can only do that during the first 6 months of your US filing, then you have to get a priority document and send it to them. Sometimes you need a POA, and but rarely these days. In the old days, you always had to get a power of attorney. You had to get it legalized through the US system to get it to them, and that was incredibly difficult and expensive. Now that's not required by any country other than the Middle Eastern countries. And it's just to give you an idea, if you want to file a trademark registration in the Middle Eastern countries, you start by notarizing a power of attorney locally, then you go to the First Circuit Court and have it legalized or recognized there, and then you go to the Lieutenant Governor's office and have it legalized there. Then you courier it over to a embassy, like the UAE embassy on the mainland, and it first has to go to the State Department, and the head of the State Department has to say, yes, this is a state of the United States, and then it goes to the embassy, and you pay a huge stamp tax or tax to the embassy, and then you ship it over to the Middle East to your correspondent. And I think, so that used to be for all countries, but in the last 15 years, everybody's got rid of it, except the Middle East. And the Middle East not only has that very elaborate, difficult protocol, which I think is just for revenue raising, but they also charge huge filing fees. So if you want to get filed in the UAE or another of the Arab countries, it's $8,000, and everywhere else it's between $600 and $2,000. So just to be aware, but apparently those markets are important enough, so we still have clients who do get registrations in the Middle East. Next slide. Okay, so this is the Madrid. As Martin say, you file a single application, and you tell Geneva which countries you want it extended to, and so after you file the application, usually it just sails through and you get your registration within 3 months. Occasionally there's an issue and you have to argue it, but that's fairly rare. It's just almost too easy. Next slide. Except don't do it yourself, as Martin says. There are a few tricks. Once you get your international registration, Geneva sends it to all the countries that you requested protection in, and each country examines it. And in a good case, they'll just grant it. And within, I think they have 18 months from your initial filing date to grant it. And if they don't grant it, you'll get a refusal. Once you get a refusal, you must hire foreign counsel or give up. And foreign counsel will charge depending on where it is. Again, Norway is difficult and expensive because it's a high cost of living. China is fairly inexpensive to argue refusals, but China is the only country I've found where a first refusal is a final refusal. So the remedy in China for a refusal is an appeal, which is still inexpensive, but not quite as inexpensive as having a refusal argued in Singapore is going to be under $1,000. An appeal in China is going to be over $1,000. Just to give you some kind of idea. And it's hard to win appeals in China. There's a better success rate at the next level, which is like a people's court challenge for whatever reason. So you can keep going. In any of these cases, you can keep trying. It's just a budget. It's a budget item. Next slide. Okay, so once you get your Madrid registrations, and as I say, usually they sail through and they're easy unless you get a refusal. You have a renewal opportunity every 10 years, and if you're filing individually in each country, you have to renew through foreign counsel. You get a letter from foreign counsel saying it's time, or you tell foreign counsel it's time, and they'll send you the paperwork, and you'll go ahead and renew. And it's usually not too expensive, less than the initial filing, but it's still an expense. If you have a Madrid, it's wonderful. You just renew centrally. You just tell Geneva, I want to renew in all these countries. They give you the choice. Do you want all the countries or just some of the countries? And it's a fee, and it usually just sails through. The problem is that a few countries require maintenance. They require you to prove you're using it. And that's a little tricky. So the United States has always had this requirement, so that you don't have to worry about that. That's for the foreigners, right? When the foreigners file into the United States using the Madrid, they have to worry about a 5-year filing. It's between the 5th and 6th year filing. And it's kind of only a few countries require this, so a lot of people miss it. And for us, we have to worry about the Philippines, okay? And I just found out last week we also have to worry about Cambodia, because I got my first Cambodian grant last week under the Madrid, and it came along with a warning. You have to file a statement of use. So remember at the beginning I said the United States seems to be the only country after Canada changes its law where you have to show you're using it in the country in order to get a registration. So you don't have to show you're using it in a country to get a registration in all countries of the world, except the United States that I'm aware of, and except for Canada until June 17th, okay? But in certain countries like the United States it's continued use, but the Philippines and Cambodia, you have to submit a declaration of use showing you're using it in the country, or they'll automatically cancel it. And so what's very common with clients is they want all the Asian countries, they designate the Philippines, they get it, no problem, and then 3 years later they lose it because they haven't used it there, okay? And so are you aware of other countries other than the Philippines and Cambodia? But Cambodia, we haven't filed in every country in the world, most of them. So, there may be other countries out there, but just when you get your grant, when you get your registration, examine it closely, because the trademark office of that country will tell you what you're required to do. Next slide. Okay, so this is the thing. So you might think the Madrid is wonderful, and you want to use it for everything, even a single country. But generally, you need at least 2 countries, if not more, to see the cost savings, okay? But the other thing that's very important to recognize about the Madrid is you can't vary your mark. And it's a rare mark that will get through every country of the world, or even 5 without a refusal. And so there's a lot of times there's a very good reason to change what you're filing for a certain country. That's particularly true of Asia and particularly true of China. We get an awful lot of refusals from China, and I think not only they're strict, but there are a lot of marks registered in China. So there's a lot of conflicts there, and it's very good idea. You can do one of two things. You can try China and see what happens, or you can ask your China correspondents to look into it and predict a result. And if you just do the see what happens strategy, and a lot of times it will depend on sensitivity. If you have a very big project and you want to make sure nothing goes wrong, you ask the foreign correspondent for their opinion right off. But if it's a little more relaxed, you can try it, and if you get a refusal, then you can go to the China correspondent and say, what are my options? How else can I protect the mark? And there's usually a lot of options. You can vary the mark, because as I say, you don't have to prove you're using it, so you vary the mark so you get the protection, but it's for a somewhat different mark. Or you do a transliteration, the phonetic translation, or you do some equivalent, or there's a lot of options. You usually can get some kind of protection, but not usually the exact protection you're getting in the other countries. And you might need to do that for other countries as well, but Asia seems to be the one where we get a lot of refusals. The other thing that's interesting, it's not on the slide, is examination. Most countries will examine for likelihood of confusion. They won't let you register a mark that's too close to another mark. Well, there's a huge exception to that, and that's Europe. So remember I said, the use burden, most countries say the use burden comes from, well, the United States say you have to prove use, and in other countries you don't prove use, but you can get a cancellation if you don't use it. Well, Europe takes the opposite view to examination for likelihood of confusion. They won't examine for likelihood of confusion. You can file the exact same mark for the exact same class in Europe, and they won't refuse it. But what they will do is they'll tell the registrant of a confusing mark that you filed and give them the opportunity to do an opposition. And so we have lots of oppositions in Europe, whereas we wouldn't have in other countries. But that's good to know, because sometimes there will be an exact mark, and either the guy doesn't care, they don't have the budget, they're not using it, and so sometimes there'll be every reason to file into Europe and see what happens. Okay? You can price out a Madrid filing very easily on that website, and you'll find out it's very inexpensive relative to individual filings if you're doing more than two. You have to remember that we charge for doing it, but it's pretty easy, so the charges won't be too high. We more charge for the task, because we have to do it right, we have to calendar it, we have to track it, so usually our fees will reflect a little more than the time it takes for us to file, because it's not very long. And you have to also budget in foreign counsel, because you'll probably get a refusal if you pick more than a few countries, and even for a few countries you'll probably get a refusal. But sometimes, it depends on the mark. You can try to search out a mark in advance and predict it, but it's usually difficult to search certain countries, and particularly China again. China's interesting. You can search China using commercial products, but you won't get a good search unless you ask a competent Chinese firm. There's a huge variety of Chinese firms. Some are very inexpensive. Sometimes you can get a good result with an expensive firm, but if it's a difficult case, the more competent, more expensive firms, which are still not expensive, are the way to go. And even they can't search it, because there's some problem with the database that even they can't get good information. So I've even had local counsel call an examiner over in the office and ask them about the availability of the mark. And I don't really understand it, but for some reason, they're not always able to get current information on the database. But China also has one other peculiarity, and that is that they have subclasses. Most of us have 45 classes. There are 45 classes. Well, China has subclasses. And so sometimes you can get in there in a subclass for a similar mark, and you couldn't do that in another country because it would fall in the same mark. So again, it has enough complexity that consulting with a good Chinese trademark firm will make sense. I guess I wanted the next one. So these are no, that's fine. So these just gives you the range of values. As I say, Middle East is horrible. But I've gotten registrations from Asian countries for as little as 600 is kind of the low side, but it's possible. Next slide. So I have a section on enforcement from last year, but I'm not sure I'm going to talk about it. We still have time?
Maybe 5 minutes if you could. I think it's an important topic.
All right. So enforcement, basically three ways of enforcement. Cease and desist letters, we're all familiar with those. We've read about them in the news a lot. Registration with border control and contested proceedings. Next slide. So cease and desist letters, you can handle it. The best way is to have foreign counsel write it, because there's a number of problems with having us write it. It's interesting because it could be an unauthorized practice of law in the foreign country. I guess we don't have to worry too much about being disbarred by a foreign country, but it's technically it's not appropriate. Maybe it may not be as effective as getting a letter from a known law firm in that country, and you probably won't do as good a job. But for low budget, I think sometimes that happens. The American attorney will send the letter overseas. The effectiveness obviously varies with circumstances. We did have a situation in Korea where I think even we had a Korean counsel write it, and the guy said no. It was the same case in which our distributor registered our name over there, and then wanted a lot of money for us. Well, when we wanted to change distributors, they said no, because we have your trademark. And so we had one of the top firms in Korea write them, and they said no, you're going to have to pay for it. And so we got it back, and we used the Paris Convention as leverage in the negotiations. I think we still paid too much. Remember that Paris Convention that said that if your agent or your distributor registers your mark, then you can get it back. So we had leverage, but we still had to pay a lot. So that's what I'm saying. Some people get scared and they'll give it right back to you, and other people they'll hire a good attorney and say no. Next slide. Border control. I'm only familiar with our border control here. You can register trademarks with border control and try to keep counterfeit and infringing products out. I believe foreign countries may have similar provisions. I don't know if Americans need to use that because they're not protecting markets overseas, but potentially. So you would have to ask for foreign counsel whether there's legal regulations that would allow them to register with border control, and obviously the foreign counsel would have to do that. There's not something you could do, or at least I couldn't do. Next slide. Two types of contested proceeding. One is the proceeding within the trademark office of that country, which decides who gets the trademarks. Those are opposition and cancellation proceedings. And so for example, I explained that if you file into Europe and somebody with a similar mark doesn't like the fact that you're filing into Europe, they can file an opposition proceeding. That's a contested proceeding within the trademark office. Usually not too expensive, not like full-on litigation. We've done European oppositions for under $10,000 and get a decision. They're very efficient there about that. Again, in Asia, it shouldn't cost you more than a few thousand to get a first decision. Again, you can keep going. And then the infringement lawsuits, and obviously those are going to be more expensive. The United States is still the most expensive place to litigate trademarks. You can spend easily hundreds of thousands litigating a trademark in the United States. But they're still going to cost in other countries relative to other proceedings. And in Europe, there's fee shifting, so you generally have to pay, even an opposition proceeding, you generally have to pay the fees of opposing counsel if you don't win. But again, the fees aren't anything like the US. So, we're still the top of the heap for charging money. And I think that's it. Well, maybe not. Well, let's go to the end. Yeah. There. So that's me. Okay? I don't have a booklet, but you can reach me there.
Thank you. Thank you very much. Okay, let's open this up to questions, please.
Yeah, actually, I don't know if Martin had any comments, because I got to comment on his. Any corrections? Should
Is this on?
Martin, I've known
Yeah.
Martin so long, I know he knows a couple of things I don't.
Yeah, Seth and I have known each other for many, many years. A couple of things with respect to registering with border control. Yes, register in China. They do allow registration. And the interesting thing about registering with border control in China, they stop infringing exports. If your most likely infringer is your own distributor and manufacturer. And if you have a registration in China, by all means register the brand name with customs in China so that if there's infringing products coming out, hopefully they'll stop. U.S. Customs is supposed to stop infringing imports, but they're, in the practice, the real issue they're looking at is terrorism, so they may not be focusing as much on infringing items coming in. Madrid Protocol, there's one major flaw which creates an issue as to whether you really want to use Madrid Protocol. Your Madrid Protocol international registration is dependent on your U.S. application for the first 5 years. All your eggs are in one basket. If you use the Madrid Protocol and get registrations in multiple countries, and then your U.S. registration is canceled or doesn't issue, and your international registration is less than 5 years old, the international registration and all its extensions of protection in every other country dies. So every time I see an opposition, potential opposition, I want to go against somebody else. The first thing I look at, if it's an international registration extension of protection, I see if they have what their central registration was, where their basic registration was, the domestic application they filed on which the Madrid is based, and I see whether I've got prior rights in that country. And I try to do a central attack if I can, so that I can knock out not just that one country, but every other country in which they have registrations. INTA is a lot of fun. It's not an association of lawyers. About half the people are not law firms, half the members are not law firms. They are the Fortune 500 companies, and they have in-house trademarks, paralegals, and counsel. And you go into an INTA meeting. It is truly an international meeting. I've been going to INTA meetings since the 1980s, and in association with one of them, the International Anti-Counterfeiting Coalition, I was representing an international designer manufacturer. And I walk into the meeting, and it's supposed to be a meeting of the Anti-Counterfeiting Council in the Americas. And I walk into the meeting, and everyone's speaking Spanish, because it was one representative from each country, except for me representing Hawaii and the guy from New York representing the United States for this designer. And probably the guy from Brazil was probably speaking Portuguese. There are various other war stories that I could tell, but we'll just leave it open for questions, and we'll throw things in.
We just, with respect to the central attack, there is a savings provision that you can save each of your baby applications if your Madrid gets successfully attacked, but it's not easy or expensive, so Martin's correct that if you anticipate a central attack, then Madrid may not be the best option.
Questions, anyone?
Sort of have a multi-part question, so I apologize in advance, but I'm trying to keep it in order. You talked a little bit in the beginning about Kona coffee, and as it's sort of being a generic term, you talked about regional designations, a little bit even about appellations and things like that. So and I don't know when the first Kona coffee farmer planted Kona coffee and created this phenomenal brand, but had they at that time decided, I want to register Kona coffee, would they own Kona coffee and no one else could make Kona coffee or write Kona coffee on their website? And that leads into the next question.
So the question is about Kona coffee and if the first Kona coffee farmer had registered it. Actually, they did. There was somebody who tried to, and if you go to the U.S. Patent and Trademark Office website, you will see they've tried to. I believe I know the attorney who did it, but it ultimately was not issued because they weren't able to prove secondary meaning, if I remember correctly. I haven't looked at it for several years, but yeah, if you want a geographic designation, you can indeed. Same thing for Idaho potatoes. The issue is going to be, what about all the other people in the area? And that's why there's the secondary meaning requirement, because as the area became recognized for having high quality coffee, other people in that area have the right to be able to stop using or to be able to use that brand as well. And I have to make a disclaimer here. What I say now only represents what I may particularly think at this time. It does not represent any opinions of my law firm or any position I may take in the future, because I do actually represent people in all these various industries. So you cannot use this video against me in any future court proceedings.
The secondary question would be, suppose the word he did get it. It went through the USPTO and the mark was granted. And years, I don't know how much time that lasts. I know but supposing you were, then what? Then somebody else puts a Kona coffee on their bag.
You're asking a very sophisticated question that relates to U.S. law. There are two parts to it. The first is whether the registration can be canceled on the basis of being a descriptive mark lacking secondary meaning. And that is vulnerable. U.S. trademark registrations are vulnerable to that kind of attack until they have become what's called incontestable by filing a Section 15 declaration. You can only file a Section 15 declaration after 5 years of exclusive usage. But once you get that Section 15 declaration filed, that registration becomes so much more powerful. I have actually delayed filing lawsuits when I had a registration that's 4.5 years old, so that I could become 5 years old and file the Section 15 declaration. Also, a registration that's more than 5 years old in the United States, it cannot be attacked on the basis of someone having pre-existing rights, and that's regardless of whether you file a Section 15 declaration. It is critically important to do this. The second part of this is what's called fair use. When you have a trademark, you are subject to what's called fair use. There are two kinds of fair use. One is called classic fair use, and that is being able to use the descriptive term in its primary descriptive sense. That's digital for computers, for example. The other one is nominative fair use, and that is where you cannot really conveniently identify who you're talking about without using their brand name. And it arises from a case relating to New Kids on the Block, where a newspaper had said, we want to vote for who's the favorite member of New Kids on the Block, and they got sued for trademark infringement, and the court said that, hey, wait a minute, you can't refer to New Kids on the Block except by using their trademark. So those are the two kinds of fair use there are. So even though you may have trademark registration and trademark rights, those do not stop you from the doctrines of fair use.
I have a slightly different answer, which would be exciting. So Martin's right, after 5 years, you can't successfully attack a registration on most grounds, but there are two grounds you can. One is fraud and one's genericness. Coffee is clearly generic. And abandonment, but I don't think this is the issue. So coffee is clearly generic. Kona is close to generic. It's a geographic indication. I've never had a case, so I wouldn't know what the research says, but it's possible you might be able to cancel it based on the genericness doctrine. The other thing is if there has been other people using Kona coffee during that period, then they're not an exclusive user. When they file their combined declaration saying they have an exclusive user, that would be fraud on the trademark office. So I think there's a possibility of canceling that. I think as a practical matter, public policy would say that nobody gets it. Nobody gets to exclude it.
Just to confirm, so what you're saying is then it's I'm going to use Kona coffee because it's simple. So Kona coffee, the first farmer, he goes out there, he registers it, he's granted that trademark. A bunch of other guys start using it too, and he's like, wow, these guys are out in the marketplace using my name, but if I wait 5 years, and I get this sort of permanent use on the mark, then I can go back and tell those guys they're out. But what you're saying is that maybe that's not the case.
I don't think it would work.
You don't think
not in that case. I'm pretty sure it would.
So how long do you
but I can't
generally
guarantee
wait
it.
before you file a mark, either internationally or domestically?
Well, that's a
Think
generic
someone's
mark.
infringing?
You shouldn't be filing it in the first place. You don't file. Martin talked about selecting good mark, and most clients, they don't do that. Or they select something that sounds good to them that's descriptive, and they won't change it when you tell them you shouldn't register that. You shouldn't continue using that. So if you're going to go after a generic or highly descriptive mark, you're asking for trouble. You're going to spend tons of money, and you're going to eventually lose it at the end of the day. I mean, there's some descriptive marks that work and they're protectable, but you're still going to spend more money keeping people off it than.
Well, maybe Hawaiian Airlines would have been a better one to use, because obviously that's entirely descriptive. But I'm sure
there's not a lot of airlines, so there's, if Hawaiian Airlines was Kona Coffee, then they wouldn't be able to keep it as well as they have. But that's an example of you're right. That is a geographic designation plus a generic word, and has been registered, and they had to just demonstrate acquired distinctiveness.
It is a public record that I registered the name Hawaiian for airline services. I differ from Seth in some ways. Whatever he said, I say as well. When you file a petition to cancel someone else's trademark registration, if the registration is more than 5 years old, then you are only allowed certain grounds. It is incredibly hard to prove fraud at the Patent and Trademark Office. And Seth is right. There are grounds that you can petition to cancel on the grounds of fraud. There have been attacks on Section 15 declarations on the grounds of fraud, but they've been unsuccessful. It is something where if someone decided to file a lawsuit, because courts can also invalidate trademark registrations, that would be a very interesting situation. But I think that you could, and I have to say that I have registered geographic place names as trademarks for clients. And that's why I may have a different view from Seth, because I am going to have to defend them and have defended them in court or in domain name registration proceedings. I will give the same advice to you guys that I did for a company that you all know and love, which I'm not going to identify. Gee, you want to pick this geographic term? Well, you have two choices. You can either choose the geographic term because you think it makes sense marketing-wise, but you're going to have a hard time. You spend a lot of money on me, but if it works marketing-wise, maybe it's worth it. Or you can change your brand. Client thought, said, I'm going to keep the name. Client is very, very successful. I had, at that time, said, gee, would you be willing to sell the business for 10 million bucks? He said, no, I don't think so. He makes more than that a year. He's got 15 different locations, hundreds of employees. He's spending a hell of a lot of money on me, but it's worth it for him because the brand was worth it. So if you want to spend a lot of money on attorneys, by all means, you can go ahead and pick that brand. Look at McDonald's, one of the most powerful brands in the world, and it's a descriptive term because it's a surname. So I have had to deal with these, and that's why I have a different perspective from Seth, because I deal with it from the viewpoint of one who has registered geographic terms for coffee and other kinds of products. And it's also a public record that I filed a petition to cancel a trademark registration for Hawaiian for potato chips owned by Birdseye. And the real problem there is that the registration is now incontestable because it's more than 5 years old. I had filed it before it became 5 years. This is all public record. Just look at Hawaiian for potato chips. So that's why you have to look at what the practical realities are. And if you really, really, really want to spend the money, you can achieve a lot, but there's no guarantee that you'll be able to win. And so the question is, business-wise, what's the wisest use of your resources? Because ultimately, all of this stuff is coming out of your bottom line. And you have to decide whether it's worth spending the money based on your bottom line.
Yeah, I agree with Martin that a cancellation proceeding would be difficult and with an uncertain outcome, and I have also registered geographic designations.
If you take a name like Kona Coffee, since we're using that as an example, and you change the spelling and say spell the word coffee with a K, how much easier does that make to then trademark?
Doesn't make a difference to the examining attorney.
Doesn't it then be changed from a descriptive word to a coined word, or?
Misspellings, obvious misspellings by the usually are not something that'll get through a sharp trademark examining attorney. There are a lot of trademark examining attorneys now. What, 500 something? I remember when it was 100 and some or less.
That's a lot.
Yeah. Each trademark examining attorney is different. They are attorneys at law, and they're all trained, but they all vary in experience. And they have supervisors, and specifically, every time a trademark application gets approved for publication, there's a section of the publications branch at the Patent and Trademark Office that reviews all the published the approved applications. And they will sometimes send it back to the examiner saying, you missed this. So there is quality control over there, but they're still letting some things through, and it's very inconsistent in some senses. Sometimes my partner Carrie and I are frustrated because We get applications and registrations, they're rejected, and somebody else does one that's very similar, and it goes right on through. We have one right now where our client had a major problem in a descriptive refusal and had to abandon that application and file based in connection with a logo. And then somebody else filed an application for almost exactly the same mark, didn't get a descriptive refusal. So we're really upset about that kind of stuff. But they're human beings. They're trying to make judgments. And so there's going to be some inconsistencies. And you can say the same thing with respect to foreign countries. And just remember, we think in English in America, but in foreign countries, it's a different language, it's a different culture, and there are different principles that are involved, even though the general contours of the laws are generally the same throughout. But misspellings will not help you in the U.S. Because they will be usually, in fact, when you file a trademark application with a misspelling, what will happen is they'll assign you a pseudomark, which will be the correct spelling, so that other examining attorneys and other people will be able to pick up your misspelling when they're doing a search for the correctly spelled word.
I think the important thing to understand is trademarks are not always seen, sometimes they're heard. And there's no difference between coffee spelled with a K and coffee spelled with a C when you hear the trademark. I'm not sure whether it might be slightly easier to get it through with the K spelling, because sometimes you can argue distinctiveness, you know, that people will remember the K, but you still have the problem with the auditory, that it'll sound the same.
Ash.
That gentleman was first.
Oh, Dennis.
A lot of times, a tagline is synonymous with the brand. Can you copyright or trademark the brand tagline?
Sure. Yes. The answer is yes. It's basically, if it's used in conjunction with services, usually services or goods, if it's on the label, it's generally subject to trademark protection. I don't know what you meant by synonymous with a brand.
Well, for instance, just do it, synonymous with the
Right.
brand.
It's generally predictable by trademark. Martin might have a different answer.
Well, names, slogans, and short phrases are not copyrightable. And the Copyright Office used to have a circular saying that, but they've taken it off their website. But so there's no copyright. With respect to slogans, yes, you can register them, but again, it's only in connection with particular goods and services. So just do it for Nike. If you look it up, it's going to be registered in connection with particular goods or services. And it still has to be used in connection with those goods and services, just like any other brand would have to be. One thing that we have not discussed is that when you're filing a federal trademark application, most people file based on intent to use, saying we intend to use this trademark, and then you have to file evidence of actual usage. You have to file evidence of actual usage when you file originally if you want to do it as a use-based application. But regardless, as Seth said, you do have to present evidence of actual usage if you're a U.S. entity trying to register based on intent to use or actual usage. You can get a registration if you're a foreigner without showing actual use, but then you get tripped up by having to file that Section 8 declaration between the 5th and the 6th anniversary, as he was mentioning. So anyway, what you have to do is make sure that your specimens that you're showing how you're actually using are going to be acceptable to the examining attorney. And they are fairly strict about it in certain areas. So for example, clothing, if you submit a photograph of a piece of clothing with your brand name printed big across the chest, they will reject that on the grounds of being a non-trademark ornamental usage. There are all kinds of other issues with respect to specimens that only someone who's an experienced trademark practitioner will be able to tell you about. So you need to be aware of the fact that when you're using the brand name, you should actually consult with and coordinate with your trademark attorney to see how you're doing it, because if you don't and you adopt and use the trademark in a particular manner that's not acceptable for trademark registration purposes, that's a waste of money. And if you're not experienced in trademark law, then you'll submit it and you'll get an office action back saying, I reject this because the specimen is unacceptable. I mean, that's several $100s right there. Whereas instead, if you just said, this is how I plan to show it, and then you show that to your own attorney, the attorney can tell you, there's this problem, and this problem, and then be able to help you create the specimens in a manner that should be acceptable. And don't be too fancy with fonts. I had a client once where they had a trademark with word contained the letter O, and it was a long word. And the only way they used it was with a graphic where the O was a cresting wave, but it did not close. And the examiner refused that. So you got to be really careful about how you're actually using the trademark.
Let me just throw in one thing that I forgot to mention. When Martin originally was talking about the ability to protect trade dress in foreign countries, he said many foreign countries will not protect trade dress, and that's, you know, the appearance of a product as protectable, and I guess the Coca-Cola bottle would be an example. Oakley sunglasses might be an example.
Fruhoff trailer.
Which one?
Fruhoff trailer.
Oh, I don't know that, Charlie. But anyway, but there's a very good option if you do it early, and there's something called industrial design. It's like a design patent in the United States, but it's usually very easy to get in foreign countries under a convention named after a Swiss city. What's the convention? Oh no! It just became available in the United States recently for U.S. Applicants. Hague Convention. Yeah. So, oh, that's not Switzerland, is it?
It's Dutch.
Oh, my mistake. Anyway, so it has a central filing like the Madrid. It can be very easy in most countries except Japan and the United States. The United States treats it like a design patent. But if you do it early, it has to be within the first 2 years of your public deployment of the product configuration. It's a very powerful tool to get protection in multiple countries. It also has a limited term. So, patents have a limited term. Trademarks ultimately are good as long as you're using it. So there are certain drawbacks, but it's also very powerful. And particularly if you want protection in foreign countries for I don't know, 15, 20 years going out.
Seth and I have discussed it's a royal pain in the butt to use the Hague Convention because it uses very similar drawings conceptually to design patent drawings, but they're not the same as design patent drawings. It is such a pain in the butt that when I met with, I think, a German correspondent who was visiting, he said, yeah, we don't use it either. It's just so much of a pain in the butt. So you just do, what you can do is file a U.S. design patent application and then file corresponding country-by-country applications in the foreign countries that are of interest if you have enough, something that's unique enough that justifies the cost. But the problem is that trade dress, you have to establish actual usage and a lot of it in order to be able to have enough recognition to be protected in trademarks. But for design patents, you have to file the application before the before the design's been publicly disclosed in some countries anywhere in the world. So you file your U.S. application first because you have to. You cannot file patent applications in foreign countries first because you might invalidate the U.S. patent if you get one. You file a design patent first, then within 6 months you file in the foreign countries, and that's when you can do the design application in Europe or elsewhere. But I would probably do it on a country-by-country basis because of the potential problems there are. Unless you can do like 10, 15, 20 countries, then it might be worth the hassle, right?
Yeah, well, I like the Hague, but it's difficult. It's tricky. It has a lot of tricks. It's not like the Madrid. You have to do it carefully, and it's a tricky filing. But if it works, it's really easy to get protection. And it's just Japan's the problem, and the United States. So the United States examines these things very, very much differently and more strictly, and Japan to a certain extent too, not quite as much as the U.S. Whereas the other ones, they just rubber stamp them. So.
Yeah, let me point out that design patents in the U.S. are not the same as this design registration that we're talking about. The United States does not have something that corresponds to the design registration. It's a junior kind of design patent, and one of the reasons why the United States doesn't have it is because the car manufacturers did not want to have these registrations available, because if there were, then the insurance companies would go over to Taiwan or elsewhere and get cheaper ones, cheaper replacement parts. So that's why every time design protection legislation has come before the U.S. Congress, it's been defeated. So you can file in foreign countries based on a U.S. design patent, but we do not have this kind of a registration of designs in the United States. It's an area of law where we do not have it, but most countries in the world do.
Ashley?
I have two Madrid questions. The first is, if you do an international application for maybe a handful of countries, can you amend that application at a later date and add countries? Or
Yes.
do it all in one crack?
Very easily. Click, click, click.
And then the second question.
And you even get the choice, you're very kind, you even get the choice of saying, I want this to become effective upon renewal. Because, what if you're 6 months away from your renewal? You can say, oh, I want it to become effective on renewal, so you only pay for that country on renewal. So they make it it's very user-friendly.
My U.S. trademark is in classes 3 and 5. If I do a international application, in your opinion, are there any countries that a Madrid Protocol might not do the job and I would need additional local protection?
I'm not, that's kind of a too broad a question. I think.
Actually, when you get a Madrid Protocol extension of protection from foreign countries like Europe, they usually say that you're granted the same protection as a domestic trademark registration in that country.
Right.
So you will.
After Seth's comments about the China sub classifications and so forth, I'm wondering if that was.
No, you know, I guess what should happen in China, and I'm not sure because I know practice there and I haven't had that much experience. But what should happen in China is they're going to look at the goods and services and decide what subclass it goes in. So Martin's right. It's supposed to be examined exactly the same, and the quality of protection that you get at the end should be exactly the same. You talk about amending. If you designate a country, you can say only 3 or only 5. If you have 3 and 5, you can't say, I want 6 also, if the underlying application is only 3 and 5. So you can do things, in some cases you can even do, I don't know if you can do disclaimers, because most countries don't recognize disclaimers, but you can narrow for certain countries, you can expand. But my comments about China were usually, if you have a problem in China, then you can refile something a little bit different to get it through. You usually can't do that through the Madrid because you're stuck with what's in the Madrid. You're stuck with the underlying application, which is usually your US application that goes to the international and then goes to the country. Again, you can narrow it, but you can't expand it.
Japan also has subclasses.
I learned something new.
I'm actually about to, after this, I'm having lunch with a distributor in Japan to go over contracts. First time distributing my products out there. I only have a U.S. trademark on my store. So 2 questions. One is like, how long does it, first, is there an easy way you guys can do a search to find out if there's anything pending from him or anybody else? What does it cost? And how quickly can it be done?
Okay, you can do a search, but it's not going to be good because there is an English language Japanese database of trademark registrations, Japanese trademark registrations. But I've searched for it for trademark registrations I know exist because I have them in my hand. I know the registration number. I do a search, it doesn't find them. No trademark search in the United States is ever 100% reliable. You will never get a 100% reliable trademark search, no matter how much money you pay. And so what my advice is to clients, if they have a trademark, they want to have a trademark search done, do a search, recognize you've got a problem. If it's you're spending millions of dollars, then do a second search with a totally independent search company. And hopefully you'll reduce the uncertainty, but you will never be able to get to 100% certainty. And after about spending $5,000, $10,000 in searches, most people don't want to spend any more than that. So same thing for foreign countries. You can ask your foreign correspondent to do a search, but some countries have not computerized all of their trademark records. And some countries allow rights based on unregistered prior usage. So you cannot do a 100% reliable search.
Yeah, so I have a different answer, but I mean, I don't disagree with Martin. That would be dangerous. But we have a great guy in Japan. I mean, we work with several but I know Mr. Habu, he's going to search. He almost never misses anything. He's given me his predictions have been about 95%. I don't know why, I'm lucky. And he'll do a search for $600, and it'll be very close. And the other thing is you can go home today and file it through the Madrid, but if it's going to be the only country you're doing, I would go through Mr. Habu or another foreign firm.
How old's your registration?
2013?
So it's too late for a priority claim.
Yeah,
but-
I would file Madrid. I would file Madrid because you can do that immediately. You can do it right now. Just go file Madrid. You can designate Japan. It's more than 5 years old.
But he should have an attorney do it, right?
Right. You should have an attorney do it.
I did file it myself, that one. But,
You did? You filed the Madrid yourself?
no, I haven't.
It's interesting. It's very interesting because
I'll be honest, I'm too busy.
because the countries, what's happening is, foreigners who don't want to spend money on U.S. attorneys, what they do is they go to their foreign attorneys, like particularly China. I'm not picking on China. I really like China. They'll go to their foreign attorneys and say, I want to save money. The foreign attorney is not allowed to file into the United States, but their client is. And so they tell their client how to do it, and their client does it. And that's been causing problems for the office. So the US Patent Office is going to change their rules. So companies, foreign companies, are not allowed to file directly inside or make arguments. So through the Madrid, they'll usually get a, you know, it's funny because we have all the problems with foreign offices with the Madrid, but the United States is the most famous. And I get a lot of work from foreign attorneys because what the United States does is object to the description of goods and services. It has to be really crystal clear, and they have a whole list of what's acceptable.
Canada's worse.
Well, it could be broad, but generally speaking, if I say, all right, I want to get a Madrid submission for Japan, maybe like a couple others, but let's say it's just Japan today, what would I expect it cost? What would that range be?
What would it cost?
I mean, I know what it would cost if I do it myself because I looked it up, but if I don't want to, I want to have somebody professional who knows the.
I ballpark 2,000. You know, beginning to end, no problems. We don't know if there's going to be no problems. And that's including filing briefs.
Here's a big problem that everybody has, and you don't realize you have it. You try to do stuff yourself, you're going to forget about calendaring it. If you go with stuff with a foreign correspondent, you don't know if that foreign correspondent is going to be in business in 10 years. That's why you want to be with a law firm, which will be able to put this stuff into its calendaring system. But I've had foreign correspondents in, let's see, my Canada correspondent's been merged out of existence and had others, so they succeed. My other correspondents in India correspondent left and joined a different firm and got acquired. So companies are unstable. Law firms are unstable, except for my law firm, which has been around for 95 years. But most companies are unstable. And so if you have a company that's your correspondent in a foreign country and they go out of business, you better make sure you've calendared stuff for yourself so you would know. But most people don't. And so by the time you look up, you say, oh my goodness, I forgot to renew this. Nobody reminded me. And that's why we spend a substantial amount of time bothering our clients and bugging them saying, hey guys, you have to do this renewal. And I do have a successor, my partner, who is 20 years younger than me, will carry on after I retire, but no one wants to give me enough money to retire yet, so.
Let me ask a question. There's an online question about concerns specifically about Japan, but that leads me to this slightly bigger question. Of the hundreds of small companies I've met in Hawaii and consulted to on exporting topics, I can say that there's definitely a model or a typical company. The typical company is making products and selling it locally. Secondarily, they're selling to California and Oregon and Florida and places like that. Then there seems to be a very natural gravity from Japan pulling companies from Hawaii to Japan. So I would say you've got Hawaii, US, general, Japan, Canada, and then they decide, well, let's just do the EU, okay, and Australia. Those are the sort of tier 1 export markets. Then tier 2 might be Korea, China, Taiwan, Singapore, Hong Kong, and something like that. That typical company, what do you guys recommend that they do starting now? Let's assume they have basically no trademarking going on. What would they do?
Well, I mean, you know, it's kind of a broad question, but, you know, they should select the right mark. They should search it as thoroughly as they want to, at least a good US search and maybe a cursory international search. That's in selecting the mark, because if they get the wrong mark, they're going to have problems. You know, they're going to have problems, all sorts of possible problems. So it's a little time and money selecting the right mark. File into the United States within 6 months, file a Madrid, because if you file a Madrid within 6 months of a first filing, you get the US filing date. So they can take their time at that point, filing the foreign, at least during that 6-month period. All the countries you mentioned, every one of them is in the Madrid, or it will be when Canada joins. They can do it sequentially if they want, because we talked about the subsequent designation, so they could file technically in a bunch of countries and then with, you know, after in the other countries. But again, if you do it within the 6 months, you get the filing date. The other thing is the subsequent designation has a separate filing fee, so it's more economical to do it all at once.
So, as I mentioned, most Hawaii companies gravitate towards the Japanese market. So are there particular things we have to think about with Japan? Of course, language and culture, the biggest, but from a trademarking standpoint and intellectual property.
One big problem for Japan is if your name has a geographic term in it, your product has to come from that geographic area, or else it'll be refused registration by the Japanese trademark office. And so that's a big potential problem, because if you've got a product that's being made here, you're selling it in the foreign country, like Japan, you're not going to be able to appoint a local manufacturer for saving price in Japan. So that's a Japan-specific point. With respect to the tiers of countries you mentioned, many companies actually may be in Hawaii, but they're sourcing their product, their manufacturers in a foreign country. You're most likely infringers, your own manufacturer. There's something called third shift. So Google Fortune third shift. Fortune third shift. You will read an article by Fortune magazine about the third shift problem, which is, and I didn't mention this before, gray markets as well. For a Fortune third shift, what happens is you have a product that's really successful. Well, your manufacturer in a foreign country will just put on a third shift. So I went on a seizure once for a major manufacturer of footwear. And we said, well, there are these other people who are making this product. That's a third shift problem, because they were done legitimately by the same manufacturer as who makes the genuine product. They just put an extra shift on and sold it out the back door to their uncle. So that's the third shift problem.
That
Great.
came from Italy.
Actually, these shoes did not. Oh, okay, yeah. And just because someone thinks that it's a counterfeit doesn't necessarily mean it is. I've had situations where it turned out to be genuine product and it was a wrongful seizure. So I don't trust what my client tells me necessarily. Gray markets are a big problem if you are successful. Gray market goods are products that have a very high demand in a foreign country. If you are successful, you are going to run into a gray market problem, and the problem for Japan is that gray market goods are legal. So gray market goods they're genuine products made in Hawaii, for example, and then someone comes to Hawaii, buys them at the full retail price in large quantities, and goes to Japan and resells them on Rakuten or whatever it's called on a website. And it's very difficult to deal with that kind of issue because it is legal to sell gray market products. And in the United States, it's a much more tricky question about gray markets, but clearly in Japan, they say it's legal to sell gray market products. Of course, that's a problem everyone would want to have. That is, your product will sell higher than U.S. retail in a foreign country. You can take steps against that, but it depends on what the particular circumstances are, and I'm not going to say anything more about that except to warn you that if you have a successful product in Hawaii, someone may very well take it and gray market in foreign countries. The two major paradigms I've seen of Hawaii companies expanding to Japan are, one, they got a product that's really successful in Hawaii and appealing in Japan, so you've got the gray market problem. And the other one is you've got a restaurant that people like and they want to open, somebody in Japan says, I want to take your concept and do it in Japan. Well, you better hope that you have a Japanese trademark registration already in Japan. The very first thing you do is you register your domain names and you register your trademarks as soon as possible, because the second that someone sees you're successful, they're going to steal it from you.
Is it legal for gray marketers to do the same thing in Korea as well?
Is it legal? I do not know about whether it's legal in Korea or not. I have not looked at gray market issues in Korea specifically. I have looked at, gray market is a hot issue, or it was a really hot issue about 15, 20 years ago. It's not as hot nowadays because most jurisdictions have now settled into what they're doing. And so what we'd have to do is ask a Korea correspondent whether gray market goods are legal. But yeah, it is a potential problem that Hawaii companies do have to be aware of.
All right, this is the last question, please.
I was wondering if you could comment on the Aloha Koku case and the use of Hawaiian words in brand names and trademarks.
Yeah, it's difficult. It's a difficult topic, and I think there's probably more than one view on it. I'm going to just talk about the federal scheme. You know, trademark law is primarily federal in the United States. The state law inconsistent with the federal law would be invalid. The federal law says that what the Aloha Poke guys did was appropriate, and if you put the shoe on the other foot, you know, you would want a Hawaii business that has a local word that registered a federal trademark to be able to enforce it throughout the United States, and that's pretty much what the Chicago firm did do. It was, they were politically insensitive. There is a doctrine called traditional knowledge and indigenous rights. It's more of an international law concept, and it's debated in the UN, and it's been implemented in laws in certain countries, and basically, and a little bit in the United States, and basically what it says is that you can't exploit financially or deprive an indigenous culture of intellectual property rights that belong to them. We have done it in the United States with Indian tribal names. There are part of, I think it's part of the Lanham Act, part of our trademark law that says that, you know, certain Indian tribal names belong to the Indians, and that's about as far as we've gotten. It hasn't been a popular doctrine in the United States, and it's not a popular doctrine in most developed countries in the world, but I think New Zealand has developed it to some extent, and the Philippines have. And the reason why I bring that up is it's more of a social justice goal, that if the people of Hawaii want to protect Hawaiian words for either Hawaiians or local businesses, they're going to have to do it legislatively. You're not going to get that recognition just by complaining. So those are my comments. Martin?
From a trademark point of view, Aloha is a fine trademark because it does not directly describe anything. Poke is a generic term, so they're not trying to protect poke, so they had to disclaim poke, I assume. The Chicago company was indeed fully within its rights to register it because it was a suggestive mark. It suggested relationship with Hawaii without actually saying it was from Hawaii. So under the federal laws, there was no problem with it, unless you wanted to make an allegation of unfair competition under Section 43A of the Lanham Act, saying it was a false designation of origin because it created a likelihood of confusion as to whether people were thinking that it actually came from Hawaii. You can make that same kind of argument with respect to Haagen-Dazs ice cream, and they did indeed face that kind of a counterclaim when there's a lawsuit over pralines and cream, which is a trademark flavor. Because Haagen-Dazs ice cream is from New Jersey, but you open the top and it has a picture of Scandinavia. So anyway, you can face those kinds of issues. As Seth pointed out, you do have cultural issues and PR issues. The other issue is that where I think Aloha Poke really overreached was that they were sending these demand letters out all throughout the country, but under the Dawn Donut Doctrine, you don't have the right to stop somebody from infringing unless and until you're about to enter their geographic area. That's under U.S. trademark law. Also, the people who received these letters should have written back and say, A, Dawn Donut Doctrine, you're not about to enter our geographic area, and B, you have to prove irreparable harm in order to get an injunction. You're not going to be harmed irreparably by this. So if I'm defending a trademark infringement lawsuit by Aloha Poke, I have no problem with that. And besides, I don't think they'd be stupid enough to file a trademark infringement action against a local company that says Aloha Poke in front of a local jury.
There may also be grounds to invalidate the registration because of prior users. But you know what I find interesting is, you know, the community was very upset, and rightly so, but nobody really went to a trademark attorney who could provide remedies, or at least I'm not aware they did. They asked us for comments.
Yeah, I was for comments, but no one retained us.
Yeah, and that's happened too. I know in some of the Japanese hula cases, it doesn't sound like, you know, I think they got a resolution they needed, but I'm not sure they got the best professional advice. I know we cost money, but sometimes it's better to get good advice. There may be a legal remedy that may not be expensive, and you know, just belly aching doesn't make
It's
things
important
different.
in trademarks law to do things quickly to get your filing date, because nationwide and international rights will depend on your filing date, not your date of actual usage. This is true not just of trademarks, but also of patents. So don't say, oh, I'm going to leave it till tomorrow. I've had situations where a trademark application that I filed was blocked by somebody because my client just decided to wait a couple of weeks, and somebody else had filed in the interim.
Okay, thank you very much. With that, we have to wrap up. We're over time, but I'd like to thank very much Martin Shaw and Seth Reese for being here. As I said, they are the most experienced people in Hawaii on this topic, and please engage them. If you have questions about this, they'll be here for a few minutes after the fact, and we can exchange business cards. But with that, from the Hawaii Pacific Export Council, thank you very much for coming today, and we'll see you at an upcoming seminar soon. Thank you very much. Thank you, gentlemen. Wonderful.
We're just the oldest. We're the most experienced. That means we're the oldest.
Well, he's being nice.